I have the pleasure to introduce Ari Ezra Waldman, who is currently a professor of law and computer science at Northeastern University, but as of July 1st, will be professor of law at the University of California, Irvine School of Law. Ari is an award-winning scholar and the author of 2 books on law, technology, and society. Ari has published more than 35 articles in leading law review and peer-reviewed journals, and earned a PhD in sociology from Columbia University, JD from Harvard Law School, and a BA magna cum laude in history from Harvard College. Ari is also the founder of Legally Queer, a social media educational project about LGBTQ+ law, an effort that will be relaunched after the annual event. So, Ari.
Thanks so much, Andrew. It's always great to see you, and congratulations on all of your excellent work at American. And thank you to the Williams Institute for inviting me, and thanks to all the speakers in the previous panels who spoke with great passion and pride on all of these really important issues. So I want to talk very briefly, maybe for about 10 minutes, and then open up to questions. So let's start with identifying these 2 people in the picture. This is Dylan Brandt. And he uses he, him pronouns, and his mom. Dylan is the named plaintiff in the case out of Arkansas, Brandt v. Rutledge, which is challenging the constitutionality of Arkansas's ban on adolescent hormone therapy. And Dylan's case is full, or the case against Dylan, let's say Arkansas's case, is full of misinformation about gender-affirming hormone therapy, in things like that hormone therapy is irreversible, that it's dangerous, that it's harmful, that it causes death in large percentages, that even one brief from one of the amici mentioned that the doctors in Arkansas, gender transition doctors in Arkansas, are performing surgeries on 4-year-olds. All of this has no basis in reality. The case is moving along. There is a temporary restraining order in place, but the merits of the case still hasn't been decided. So this case, along with the Florida example that the last panel talked about and all the other examples that we've been hearing about all day, I want to situate these stories in a larger context. And I want to argue, perhaps controversially, that 2 things. One of which is that none of this is new, that we've been here before, and that law is at least partly to blame for the situation in which we find ourselves in. So let's start. Well, let's try to start.
I could possibly help.
We just advance the slide. Does anyone know where, thank you. Does anyone know? Yes. Oh, this one.
If not, I'll come back and do it for you.
Does anyone know why this quote is famous or who this quote comes from? Anyone? Doubt is our product was in leaked documents in the tobacco litigation. It came from oh, that isn't working. Maybe down here. It came from a cigarette company executive back in 1969, long before everyone else knew that tobacco companies knew how harmful cigarette smoking was. The strategy, the socio-technical, socio-scientific, and socio-legal strategy of tobacco companies was not to just push back on limits on smoking, or not just to push back on bans, but to create doubt about the science, to create doubt about the harm. And as long as there is doubt, law was easily manipulatable to their goal. And this was true. This was a strategy in lots of different industries. This was a strategy for chemical companies that made chlorofluorocarbons that destroyed the ozone layer. This was a strategy for coal companies and chemical companies that put pollution into the air. This was a strategy for for conservatives who are against affirmative action, even up through Grutter v. Bollinger, the last affirmative action case of the Supreme Court until any day now, where Scalia and even Justice Thomas said that we just don't have enough information about whether inclusive or diverse classrooms are better for students or not. We just don't have enough data. We need more studies. The data is unclear. We are doubtful. We are uncertain. So what all of these groups had to do, what all conservative groups fighting advancements in civil rights had to do, was to create doubt. And as we've seen in lots of different cases on conversion therapy, cases on abortion before Dobbs, on affirmative action, even on voting rights, what we see is a series of cases where litigants as well as judges play a role in saying that even though there is a mass consensus about what the scientific reality is, how the world works, what lawyers call legislative facts or social facts about the world, even when there is a wide consensus, 99 out of 100 doctors say, for example, that all you need is one study, one example, one piece of information that challenges the consensus, and all of a sudden, poof, there's room for a conservative judge to just decide the case however they want. Law is responsible for this situation. It's not just a matter of there's a lot of misinformation out there. And it's not just a matter of the political economy of misinformation or the internet, even though those are all parts of it, right? But law plays an important role. And in fact, I'm going to argue that there are 4 ways in which law plays an important role in allowing this state of affairs to exist, in allowing just any litigant or any judge to come into Dylan Brandt's case or in any other LGBTQ civil rights case and say, well, there's that one dentist that doesn't believe in this toothpaste, or there's this one doctor that doesn't say that that hormone therapies are safe. And as long as there is that one doctor who says that, then we can decide this case against civil rights. So money, process, doctrine, and technology. So very briefly, let's start with doctrine. How does doctrine, how the substantive, how the law works, contribute to this state of affairs? Well, for all the lawyers in the room, courts use standards of judicial scrutiny. We call it rational basis, and for constitutional law 101, I think of them as hurdles on a track, right? The lower the hurdle, the lower the standard of review, the easier it is to pass over, the more laws are going to pass. At each standard of review, a judge gets to decide what's right and what's wrong, how far the state has to go to prove harm. But these standards are indeterminate. And when you look at, and I have an article coming out about this in the Fordham Law Review, when you look at cases about abortion before Dobbs, when you look at conversion therapy, when you look at affirmative action and so forth, what judges have done is they've taken these standards of review, and instead of applying them as they're supposed to, they apply them as demanding absolute infallibility from those scientists and those parties seeking civil rights reform or seeking advancements in civil rights. So for example, if there is one doctor out there who says that gender-affirming hormone therapy is dangerous and irreversible, then if the standard is infallibility, then obviously the plaintiffs haven't met their burden. It goes even further. Some courts will even cite the limitations section of a study, right? For any social scientists in the room or anyone who's ever read a peer-reviewed article, there's always a little paragraph at the end that says, this study doesn't prove everything in the whole world, right? There are limitations to this. They will even take a limitation section and say, even these people admit that their study is not perfect. So because of the indeterminacy of these standards, because of the indeterminacy of the standards of review, judges have a very easy way of changing the demands on each party and not applying the same infallibility demands to the other party. So what about process? So the adversarial process is something that we learn about in law school as at the heart of our legal system, right? Judges learn the facts of the case from 2 parties equally situated, able to offer their version of the facts, both from who did what to whom and where, as well as social phenomenon about the world. But in an age of misinformation, when everyone is treated the same, when everyone is given the same platform and legitimized in the same way by the adversarial process, you have what we call the liar's dividend. Meaning that when everything is treated as just equally as plausible or equally as implausible, then the people who are lying are legitimized. They have a leg up. They're immediately given the same platform, the same aura of legitimacy as people who have done the work, as people who are accurately interpreting scientific studies. So the adversarial process is not perfect, right? It's not the best thing ever, right? But it's given, but it has its benefits. We learned that again from the first day in law school. But that adversarial system was not built to account for rampant misinformation in litigation. And its result is a legitimization of misinformation and lies in the civil rights context. So what about money? As some of the panels talked before, there is a tangled web of conservative organizations, advocacy organizations, organizations that publish pseudoscience, organizations that represent plaintiffs or represent defendants, organizations that publish their own reports from the Heritage Foundation all on down. And we don't know anything about their donors, all of which is enabled by case law like Buckley v. Vallejo, and especially Citizens United v. FEC, and subsequent cases that have allowed all of these donors to be hidden, to allow for no accountability, no transparency, and therefore us being unable to determine the progeny of any study or any report that the defendants or that the conservative forces offer to push back against gender-affirming hormone therapy or to push back against civil rights violations. And then finally, what about technology? So there have been several panels, including we've seen a lot of talk about social media and elsewhere, including Jevon's work, which is extraordinary about the role of technology and the internet in the spread of misinformation. But the political economy and the spread of misinformation throughout, thank you, the spread of misinformation into the legal system is not just a matter of technology itself, it's also a matter of law. We heard a little bit about Section 230 before, which immunizes platforms, as Alejandro mentioned, immunizes platforms from all sorts of liability, but the way Section 230 has been interpreted and the way Section 230 has been used to simply cut off any discussion about platform liability has been used to therefore allow for the spread of rampant misinformation on these platforms. Also makes it a lot easier for judges to just say, well, I'm going to go on Google and I'm going to find out for myself. Right? And the lack of law, as well as the tools that platforms use to essentially surround their business models with First Amendment protections and other kinds of tools that immunize them from all sorts of accountability, leaves platforms out of reach. Because we can't touch them, we can't touch anything about how they spread information, spread misinformation, whether it's to judges, whether it's to amici, whether it's to litigants, or whether it's to us, as we develop our own legal consciousness about what the law requires. So the end result here is that this isn't just a story about each individual part of this. This isn't just a story about how amicus briefs are unregulated and they're just full of misinformation. Isn't just a story about partisan judges, although those are big parts of this story. It is a confluence of factors that you can see in how the legal system works, in specific decisions, in specific choices, normative choices that we have made that have enabled a civil rights agenda to come up against a wall of misinformation that's actually protected by law. And as sooner we recognize the role of all these other legal regimes, the easier it is going to be for us, not just to fight the battles as Omar does on each individual case, but also to win the wider war against a legal system that is entrenched against our civil rights. Thank you. So I think we have about, I don't know where Mallory is. Well, let's just go with questions until someone tells me to stop. Thank you. Appreciate it. Any questions? Yes.
Sometimes like litigating these cases and then also with the plot, like this is fictional. But I actually, it was interesting to me that I feel like courts are easier to exclude like disinformation and just like terrible stuff. Whereas like everything is just on a computer level. I guess just like, to get to my question, I guess, is, like, how do, like, it really seems like now the judges are getting warped by this misinformation, like in the Adams case in, circuit, like, judges are constantly bringing up like random concerns that they most certainly saw online, social media proxies, and like, how do you counteract that? Like,
Yeah.
where judges are now getting like brain rot. From
Right. Yeah, that's absolutely right. Judges are just like us, right? They have certain expertise and training that some do, not all, but we have often assumed that judges have certain training that would make them rise above or to be able to spot what is misinformation and what is not. Some scholars have argued that about the ability of courts to sift through the muck, particularly district courts. A good example of this, so I'll start with the argument for and then answer your question, particularly district courts. So in the LGBTQ context, the original marriage equality case that Vaughn Walker, who is now a former federal judge in the Northern District of California, they had a trial about marriage equality, and then he wrote a 150-page opinion piercing every piece of misinformation about the effects of same-sex couples on children, right? The idea being that, well, you have here a fact finder as a judge who's able to sift through what is misinformation and what isn't. But I think you're right, that predates, obviously the internet existed then, but that predates the kind of situation that we're in now. Another thing that people say about courts is that look at the 2020 election, that all the people who were lying about the election, they were stopped in their tracks as soon as someone sued them or they tried to get into court, because you can't lie to a judge. So there is something to say about the fact-finding tools of district court judges. But the problem that we're going to face is that the rules against going outside the record at the appellate level are just so mushy that anyone is going to be able to go to Google and just say, oh, this is what I think the rule is. A perfect example of that is Justice Kennedy in Gonzalez v. Carhart, the late-term abortion case back already 30 years ago, where he wrote in the opinion that it just stands to reason, and I am of the opinion that people regret abortions, right? And that was part of the reason why the case came out the way it did. And that didn't even need the internet, which is, I guguess my point is that this stuff isn't really new. It may be more amplified now because of the ready availability, more of this information. But we faced the same problems 30 years ago. Maybe then that the solution, therefore, is not about the internet per se. Maybe it's about what we allow into a district or appellate court case, which would therefore challenge very basic assumptions about the adversarial system in the United States. Yes.
One thing that I am noticing is that these new pseudoscience organizations are potentially violating their tax debt. And I know there's a really high burden of proof when it comes to lobbying, but it is happening right before our eyes. And I don't see any substantive offensive strategies to counter that.
Yeah.
I don't have a question.
Well, so I think that's right. There are, and people may remember it was several months ago already. It may have been late 2022, where essentially a conservative litigation organization was designated by the IRS temporarily or preliminarily as a church, which avoids all sorts of tax implications and lobbying implications, simply because the organization in its filing for tax exempt status said that they have church services. They gather for prayer circle in their anti-LGBT litigation offices, even though there was no evidence that anyone actually did that ever in the history of the organization. That didn't go forward. It was a preliminary designation. But you're right, the burdens of undoing those designations are incredibly high, and the discussion is politically fraught. So imagine a litigation group or an advocacy group calling for taking away religious designation status from an organization, then immediately liberals are anti-God or whatever. But even if we ignore the politics of it, one of the reasons why there isn't this kind of movement to do that is because not only is the doctrinal burden hard. But we don't have, the left doesn't have the kind of similar multi-gazillion dollar organizational support to fight every fight. And there's a reason why Lambda can do great work, why Omar can be everywhere, but also he's only in 8 cases of the gazillion that need to be filed, right? So without $300 million from Harlan Crow every other year to the right-wing organizations, left-wing organizations and progressive organizations have to make choices.
Yes. It's like, I mean, these are but then this is like public health. I'm gonna talk about religious organizations, about student bucket. So like the Society for Evidence in General. Like, nobody knows where they're gonna get money from. They're writing.
So what would it, so I'm going to throw the question back to you in classic law professor form. What do you think it's going to achieve? Okay, let's take away their religious status, or let's take away their 401(c) status. Now we know who their donors are. Let's just then they're going to set up another 401(c) organization to do whatever else they can do. So why would, given my limited resources, why would I spend money on that? Is it going to change the ecosystem of misinformation if a judge who's already on their side and can use any one of these doctrinal or process-oriented tools to make the decision, and has probably already made the decision anyway, why would this designation change this story? I'm not sure the answer is it wouldn't, but I'm skeptical.
So, I think
No, the threats to real people's lives is intolerable too. I think we're closer on this than our back and forth suggests. I'm not sure it's politically viable. Yes.
So one of the things that we're seeing in Florida in particular is they're passing laws that the reading of the law can be seen as even-handed, applying across the board, when they know that the enforcement of it will reflect their prejudice. And then as a consequence, courts saying, what's the problem?
Yeah.
So for the same reason that all books involving LGBT characters or that address racial history in ways that challenge white supremacy, for example, may get pulled. Another book that has incest, rape, genocide, like the Bible, would never be even considered for removal. Thoughts on the strategy that relies disproportionately towards combat that?
Yeah, so this is a great question. Another thing that's not new. Law has always been a social institution that has been enforced based on the whims of the people enforcing it. In fact, so much so that it almost doesn't matter how you write the law. It matters in the liminal space between writing the law and the person enforcing it. But one of the things that we actually do know in this exact situation from people talking on television, but also from the release of documents, we know that one of the reasons why organizations like the Manhattan Institute and others have been writing legislation, generally applicable pieces of legislation that they know are going to be interpreted in certain or enforced in certain ways, is because of the degradation of disparate impact doctrine, right? So in federal law, you used to be able to really go after laws that are generally applicable but have a disparate impact on a particular population. But over the last 30 years of conservative dominance of the courts, that has been chipped away to basically near death, such that you need to prove intent to discriminate at the very beginning, when that wasn't really the whole point in the first place. Knowing that it's going to be very hard to get any kind of disparate impact challenge to these cases, these organizations have then pursued generally applicable laws that they know are going to be enforced differently. So, and people have been doing that, conservatives have been doing that for a really long time. That was at the core of vagrancy and other types of laws, or anti-vice laws or morality laws. Like, what is disorderly conduct? Well, it's whatever the policeman or the liquor agent after Prohibition says it is, and it was always applied to public expressions of queer sexuality, right? So not a new problem. And the way we used to go after that is by showing disparate impact. And now we're not going to be as successful doing that until we change the courts. So what do we do about that now? The only thing we have is either a state-by-state strategy fighting what we can within the system, but also broader change to how we elect our state legislatures, how we determine who our judges are, right? There are no easy answers here. As Omar said, it's scary out there, and it's going to be scary out there for a while. I don't have easy answers. But when we give up, right, it becomes that much easier for them to make the decision or make the determination that these are going to be entrenched. We keep having to challenge it until we find a judge that's going to entrench our view. Yes.
So,
Christy left again, so I can keep having questions.
so it follows with what you were just saying. So you engage with law students, and some of us engage with the community, and I think there can be a tension between explaining the problems with the system, problems and or corruption, or however we want to describe it, and this comes up particularly sometimes when we talk about the Supreme Court, and not wanting to add to what some of our opponents are aiming to do, sort of tear the system down, cause the system not to work. Everybody should be so cynical. The rule, I shouldn't have to follow the rules because the whole system is corrupt. I mean, we want people to believe in a system of laws and follow the law, but at the same time, it's not working well. We're fighting against or encouraging people not to be overly cynical while wanting people to see the problem. So as a law professor, how do you deal with this with your students?
You call it cynicism, I call it anger. And I wrestle with this. And in fact, it showed up on my faculty evaluations or my student evaluation that sometimes my students leave class feeling abjectly cynical about the legal system because I teach them about the social context in which law exists and the ways in which corruption happens and the way in which things actually work in the real world. But what I'm really trying to do is I'm trying to get our students not to be complacent. I'm 42 years old, so I grew up I was a teenager in the 90s where there was no activism when I was in junior high or high school. No one was protesting about anything. The kids are all right. They're doing a lot better than my generation was already because they are angry at what this system has offered. So I'm not existing at that line between cynicism and engagement. I'm trying to move cynicism to anger and therefore engagement both within and outside the system. So I often tell my students that you're here in law school for lots of different purposes. If it fits what you want to do and it fits your skills and interests, you might work within the system. If it meets your interests and your skills, you might work outside the system as a protester or an activist or community organizer. Both are essential for reform. And that's true in any field, whether you're in public health, whether you're in clinical medicine, child psychology, all of these are social institutions that require real people to change the status quo. How do you think they got homosexuality to be decriminalized or taken out of the DSM? Well, that was people, that was protesters outside the system and people inside the system. That's what I think we need to do at all levels in law school. We need to train activists to work inside and work outside. So these things are important for students to learn because one of the things that a lot of professors do is still instill in students the majesty of the law. And there is absolutely nothing majestic about it. And the sooner all students realize that, the better our legal system is going to be. You're a Christina. All right. Thank you very much.